Final case on the docket for Tuesday, December 14th, 2021 is appeal number 121768. John Doe, H.B. an individual versus Father M.J. individually and in his capacity as a priest at the St. Matthew Parish and also the Roman Catholic Archdiocese of Kansas City, Kansas, a Kansas not-for-profit corporation. Case out of Wyandotte County, briefs both sides. Your Honor, this case is scheduled for a 20-minute argument on each side. This case concludes our docket for today.
Counsel, I would ask that each of you would come to the lectern and enter your appearances one at a time and then return to council table.
Good morning, Your Honors. Chad Bloomberg on behalf of the Archdiocese of Kansas City in Kansas. Today.
Please the court, Ross Henry Stewart on behalf of MJ. Thank you.
May it please the court, Rebecca Randalls on behalf of the appellee, HB.
Mr. Bloomberg, I understand you're arguing first. Is that correct?
Yes.
Yes. You may approach the lectern then.
Madam Chief Justice, I believe me and my co-counsel have agreed to ask for 12 and 3 on the opening argument. May it please the court. For those monitoring on YouTube, this is a case about allegations of childhood sexual abuse that occurred at St. Matthew's Parish in Topeka in the early 80s. The core issue here is whether those claims are time barred by the 8-year statute of repose in section KSA 515, or whether an exception to that statute applies under section 60-523. So the first argument and the first issue that applies to both defendants or appellants equally is a plaintiff bound by the facts that he chooses to plead in a petition? In this case, the sort of magic date we're trying to get to is June 1st, 1984, as if the last act of abuse occurred before that date, then there is no need to discuss any other statutory sections. The statute of repose in section 515 runs from the last act of abuse. There is no dispute that tolling does not apply to that statute. Instead, if the abuse ended before July 1st, 1984, which is 8 years before July 1st, 1992, then the claim is fully abolished. I think the history of this case and the facts are important because they show that the abuse absolutely and necessarily ended before June 1st, 1984. Before this lawsuit was filed, before any motions were filed, the plaintiff in this case contacted the Archdiocese to report abuse. He called from the island of Guam. And the records show that he reported abuse that took place from 4th through 6th grade. He knew when the abuse took place because that's when the movie Gandhi came out in 1982. And he stated that it happened while the priest at issue in this case, MJ, was a priest at St. Matthew's. So a very consistent, clear timeline of when the abuse happened. A couple years later, in August of 2017, plaintiff filed his petition in this case, and the allegations in that petition were entirely consistent with what he told the Archdiocese before the suit. He pleaded that the abuse occurred until he was approximately 12, between his 4th and 7th grade years, and he also sued MJ in his capacity as a priest at St. Matthew's and claimed that at all times material he was a priest at St. Matthew's. We moved for a motion to dismiss on that, but when we ultimately got the date of birth and the dates of his school attendance in the record, we were able to definitively say when this alleged abuse occurred, because that's what plaintiff said before the suit, and that's what he said in his petition. The Court of Appeals and my opponent will say that these are approximate dates or they're intentionally vague, but the word approximate is only used 3 times in this entire very lengthy petition. Plaintiff did not use.
How much your basic position here is that notice requires precision? Actually, I'm not used to our new courtroom. I need to turn on my mic. Let me re-ask that question. Basically, it's your position that notice pleadings requires a degree of precision. Obviously, the Court of Appeals didn't buy the precision that you're arguing and maintaining. What we have notice pleadings, and isn't there some latitude in notice pleadings, and why isn't it that latitude that the Court of Appeals found exists in this case right?
Justice Rosen, I agree with you and disagree with you on that question. One, I don't believe I'm arguing that notice pleading requires precision. I think Kansas is a notice pleading state that is one of the most liberal notice pleading states in the country. We have not in this state adopted the Twombly or Iqbal standards adopted in federal pleading standards, the plausibility standard. We have a very liberal notice pleading standard. But as pointed out in the case law we cited, you're entitled to use notice pleading. But if you want to abandon notice pleading and instead assert facts for whatever reason, you do so at the risk that you are bound by those facts. So in this lawsuit, if plaintiff had pled under and using notice pleading standards, I was abused approximately in my youth during times that MJ may or may not have been a priest in the Topeka area. I think that would have been sufficient. I would have had a hard time moving to dismiss on that. But the problem here is that plaintiff didn't choose to use notice pleading for whatever strategic reason to tell the story, to perhaps generate media publicity. I don't know what the strategy was, but these specific facts were put into the petition, and they are entirely consistent with what he told the Archdiocese before he filed the petition. This was his version of events. And we've cited a couple in our briefs, a couple just commentators that say, look, a plaintiff should use notice pleading to his advantage, tell enough facts to tell the client's story to make the claim credible or to explain what's going on, but always do so with caution, knowing that if you plead too many facts, you may plead yourself out of court. So that's what I think has happened here. We did not use notice pleading. We chose to use fact pleading. And when you put facts in the petition, those are binding judicial admissions that cannot be contradicted. Those facts remain binding throughout this case unless and until amended, and they've never been amended. We have discussed in this case 4 different times at the district court level whether the facts should be amended. They never were, and my opponent has both said, these I will amend or I'll amend at some point, but at the same time told the district court, these facts don't need to be amended. So that would clearly be an exception to the judicial admission rule. If the petition had been amended, this court has clearly held that the facts in the petition would no longer become judicial admissions, they would become evidentiary admissions. I'd still get to use them at trial, plaintiff could explain them, but they would lose their binding effect. But as long as they remain in the petition, they are binding facts that cannot be contradicted. The other exceptions to this rule, one is the rule on hypothetical alternative pleadings, which the Court of Appeals found these were hypothetical alternative pleadings. But this court has held that that rule applies, and in doing so, it has upheld the judicial admissions rule, that when we have pleadings about former parties to a case that settle out, we cannot use those facts. And it may be a construction case where you sue 2 subcontractors, and you say A caused the fire and B caused the fire, and then you go settle with B, or you amend to include B or A, I'm getting confused, but you can't then, the party who didn't settle out couldn't say, hey, I'm out of this case, you admitted it was the other subcontractor. That is not a judicial admission, because that is alternative hypothetical pleadings. That's a narrow exception, that doesn't apply here. Another exception are legal conclusions. For example, you claimed I had a duty, or this was foreseeable. Those are legal conclusions. These are not legal conclusions. These are basic who, what, when, where, why, how of a lawsuit. So I think what needs to happen here is we had and I think the district court had the best intentions, because the district court looked at these allegations, and I think if you give them the broadest interpretation possible, I think these interpretations are unreasonable, you get to the end of 7th grade, which is about May 1984, still before the magic date of July 1st, 1984. And we had a hearing on this. This is where I think the original error occurred in this case. The district judge asked my opposing counsel and asked us during a hearing, when did this priest leave? When did he leave? Because that's a key allegation, that all the times material was when the priest was at St. Matthew's. And the answer from my opponent was, well, this is a knife's edge case. We're right on the edge of the statute of limitation, represents to the district court, we know there was no abuse in 8th grade. The district judge asked, well, if he left before July 1984, would you have a problem? Meaning, would you agree your case is time barred because of the magic date here? The answer to that question was, yeah, we might have a problem. The district judge then ruled that we had to engage in limited discovery to determine when the priest left the parish. The document showed he unequivocally, is well documented, left in June of 1983. And we then go take a deposition. And the deposition goes on for about a half a day. And the testimony to that point is consistent, 6th, 7th grade. We take a lunch break. At lunch, we come back from lunch, and there's a note that says, I'm going to make a correction to the record. This is after a motion to dismiss has been filed, after a representation was made to the district court, there was no abuse in 8th grade. And we get on the record, yeah, I was abused in 8th grade. I just learned in a counseling session a couple months ago, this just popped into my head that I is now abused, entirely inconsistent with the allegations.
Doesn't that go to kind of the credibility, and you're saying that it's, you're suggesting either that's made up or doesn't that go to kind of the weight of the memory? And because isn't it entirely consistent with recovered memories that's going to evolve or come at different sporadic moments? And you're questioning the timing, all of that, doesn't that all go to just the credibility of the witness and of the facts that are remembered?
It would if we were allowed to create credibility issues by contradicting our facts. If there was a credibility issue or the facts had changed or a new memory had been recovered, we should have amended the petition. Because until then, you're not allowed to under Kansas law and about every case law in this country that I've found. I haven't found anything going against us. You cannot contradict your amended judicial admissions. Or you can try to, but you can't rely on those to create a genuine or valid discovery dispute that's going to, or a factual dispute that's going to require a trial. This is like Mays versus Sibagaiji. You can't use a sham affidavit to contradict your prior testimony. And this is more than testimony. These are judicial admissions. These are words that plaintiff had 40 years to draft and prepare and put into a petition. So I think that was where my opponent would like to go, is to remand this case back to the district court and have a trial about a credibility issue. But we only get there if we allow the plaintiff to improperly, and against every case I found, contradict judicial admissions.
Counsel,
I just want to emphasize something that you said at the beginning. But the petition did use the word approximate, right?
It did one time to describe the time frame, and that
Okay,
is.
but it did one time use the word approximate. So are you saying that approximate means that, May 28th or whenever the school year ended, or approximate could bleed into 8th grade? Why is that not consistent with what he said in his deposition? Approximate.
Because, Justice, I think all three factual allegations about the time frame need to be read together. Until approximately 12, that's one fact. Between 4th and 7th grade is a different fact. Those facts line up perfectly.
Right, but some people would say that, 7th grade, you're not in 8th grade until August 13th.
Right.
So you're still in 7th grade on August 12th.
But we also have to add in the third fact, that at all times material, he was a priest at St. Matthew's. And when you view all those three facts together, and they're uncontroverted, just birth dates, when he went to school, there's only one time frame that works.
But didn't he come back to that church?
Not as a priest at St. Matthew's. His assignment as a priest ended in 1983.
Right, but if it's notice pleading, you're holding this petition to pretty stringent standards, right?
I'm exceeding my time, if I may finish the question. Thank you, Chief Justice. These are standards and facts that the plaintiff put in the petition. The argument or suggestion that this priest returned and then abused, that was nowhere in the record until after we argued this motion to dismiss and had an agreement that it was all going to depend on when he left the parish. So this is, I'm not holding my opponent to anything other than what was said and written in a petition about what the dates that occurred. I think I'm entitled to rely on that.
But if he visited the parish, couldn't that be construed as he was still at the parish?
If that was going to be the claim, Justice, I would say the petition should have been amended and never was to plead.
But it's notice pleading, right?
Except when you use facts to say that at all times material the abuse occurred while he was a priest at St. Matthew's. And that's a very important canonical religious function. When you're appointed as a a pastor, as a
But
parish.
it didn't say he was appointed as a pastor.
Be sued in his capacity as a parish priest.
Right.
And sometimes parishes are separately incorporated. Under the church law, they are their own independent entity. So what we're saying is that we're departing from the petition substantially to say he was no longer abusing me when he was the head of this parish.
Do you use the head of the parish?
That's what, I mean, when you say you're the pastor of a parish and that's the capacity you're in, that's what that means. You're in charge of the parish.
That may be a technical, but maybe to someone who is not a practitioner, a Catholic practitioner.
Yep.
I mean, wasn't there evidence that this priest returned to concelebrate and serve communion? To those who may not be part of the Catholic religion, that would seem to be that he was acting as a priest in the parish when he did that type of thing.
Well, I think the rules of the Catholic faith may not be familiar to everybody, but I think they're certainly familiar to my opponent, who's filed several of these cases and knows how the Catholic Church operates.
What is our standard?
I'm sorry?
What is our standard when we look at that? I mean, do we,
I believe the standard, Chief Justice, is to plead the facts in their plain and ordinary meaning, and to give reasonable inferences, but not modifications. And the facts as pled are that this occurred while he was a priest at all material times at St. Matthew's, not as a visiting priest, not as a returning priest, not as someone who was celebrating or conducting a mass or at a funeral. That's a different function than what was pled. But I think we also need to read the record very carefully, because the Court of Appeals, I think, adopted facts that simply aren't supported by the record. The argument that there was abuse during trips to Meriden or to Paxico, that's not supported. He may have pled that, argued or given his deposition testimony that abuse occurred during the trips, but if you read carefully, it was between 6th and 7th grade. The only incidents of abuse that occurred that are clearly contradictory to the petition are those events that occurred around Christmas and at a funeral, which we established he wasn't there. So I'm clearly over my time. I'd like to give Mr. Stewart an opportunity to fill his time as well. So unless there's any further questions. I'll sit
I
down.
have a couple,
Oh, sure, yes.
a couple quick, I hope they'll be quick, because just clarification about the record that you've been discussing. Can you point me specifically in the petition where the claim is made that the at all times was a priest at the parish language?
I think that's in paragraph 4, so it'd be like volume 1, page 19, paragraph 4, somewhere in there.
And then follow-up question, from your perspective, do you have a timeline of the priest's activity at the parish? You touched on parts of that. I understand was priest up until sometime in 1983, and then no longer was, however, continued to perform certain activities.
This is the challenge of dealing with a case that's 40 years old. We have records, and it took substantial effort to get them to determine exactly where and when this priest was assigned. We have those full records. They're in the record, and they show all of his assignments, and that he clearly left St. Matthew's in 1983, that he went to go get a work on his master's degree down in Texas for part of that summer. We have all of his assignments. But the theory is, well, he just continued to come back, and that's the problem of this case. If I say, and that's what happened here, he was here, my opponent will read that record and say, oh, I was just wrong. I just learned he was in Paxico in 1987. Well, I must have been abused there too.
Well, are you saying that the facts in the record establish unequivocally that the priest was not present in the summer of 1984?
I think he was out of state during the summer of 1984. That is in the record. Do I have information about when he came back, if he visited over the weekend? I don't know.
And if that's the case, isn't that a problem for you?
I don't think so at all, because the allegation is he is being sued in his capacity as a priest at St. Matthew's. And once he is reassigned, he is no longer.
You're relying on that legal distinction.
I don't think it's a legal distinction, Your Honor. I think it's the facts that are pled that this is being sued. He's being sued in his capacity as a priest at St. Matthew's, which is it's like saying he was the principal at a school, not a visiting principal who left and came back. That's a different allegation, different theory. I'll sit down and wait for Mr. Stewart to. Thank you for your additional time.
May it please the court, Ross Henry Stewart on behalf of MJ. Counsel for the diocese has gotten into some of the details that I'm going to be talking about. I'm not addressing 6523 today. I'm only here on 6515 and the issues that we have underneath the panel's decision at the Court of Appeals. Ultimately, I have the same questions, whether or not a party can create a credibility issue and evade a dispositive motion by contradicting pleaded facts in his petition, or are those facts binding judicial admissions? And going back to the hearing that we had on the motion to dismiss, I think it's important to note that throughout that hearing and throughout that process, it became agreed and we were ordered to go do discovery by the judge based on the idea that my client left that parish. And so if he was gone by summer of 1984, it's very likely that the alleged abuse would have ended. We go and do discovery and we find out my client actually left in June of 1983, went to Texas, did a program there for his master's, came back to Kansas City to help his mother who was ill, went back, finished his program in Texas, came back to Kansas City and got assigned to Overland Park. He was never assigned back to this parish in Topeka. I don't have a full record of his whereabouts. When he did his interrogatories and was asked, did you go to a funeral in 1985? He said no, period. And the rest of that interrogatory states, I don't know everywhere I went or everybody I was with 34 years ago. Something along the lines of that. In the appellate record, it says that my client doesn't know if he went to this funeral. He unequivocally states in his summary judgment facts that he did not go to that funeral. And I think it's important to note, too, that at the summary judgment hearing, we both, the diocese and my client, both had our own statements of facts. And under Rule 141, you're supposed to respond to them. Plaintiff only responded to the Archdiocese statement of facts. There was no response to my client's statement of facts, which would deem all those admitted, which include my client left that church in 1983. There is nothing in there, and I know the appellate court took some issue with this, about whether or not my client stated unequivocally that he never went back to that parish or stated that he did not commit the acts that were alleged or anything like that that would obviously give him the relief that we're asking for. But it still stated that he leaves there then. It's been pled in the petition that at all times he was a priest at that parish, which is very specific. And it's also pled that it's approximate between ages, but not between grades. So it says between the 4th and 7th grade, these alleged acts of abuse occurred. Now, are those binding to the petitioner or not? We're stating that under case law, and has been held here before, that those are judicial admissions. They're not evidentiary admissions. They're not anything else on the record. They're judicial admissions. We're going down the course of this case based on what those allegations are. Now, it's notice pleading. You can change until the pretrial order, right? And you can go down that path and say, oh, well, we discovered these things. But if we're filing a motion to dismiss or another dispositive motion, how is that supposed to work in the state if you can contradict your own pleadings that have facts in them? How do you ever get a motion to dismiss to go through if you can just change it later? If you have evidence to back it up, which we're also arguing under this record, there isn't enough evidence to show that a lot of these facts that are being alleged or being put in briefs are not backed up by the record. There are not documents to back them up. There are some testimonial statements made by HB at his deposition about funeral in 1985 and a Christmas trip. And those are the only other two things, but the petition is very, I don't want to say narrowly pled, but it is specific in terms of the grades, where my client was, and approximation with age.
And on review, counsel, we construe those allegations in the light most favorable to the plaintiff and draw all reasonable inferences in favor of the plaintiff, correct?
At summary judgment or at the appellate level?
At the appellate level.
I was under the impression.
On a 12B6, on a ruling on a 12B6 motion.
In the review that I did, I was under the impression that if a plaintiff or a party makes two contradicting statements, that the one that is the most negative towards their standpoint would be the one that would control. And I have that somewhere in my notes here, that there was a case on that, but I was operating underneath that standard.
Okay. But to get to a contradiction, we would have to first look at the allegation that gives rise to your argument that there's a conflict only after construing that allegation in favor of the plaintiff?
To be honest, I'm not sure. And I know that I've gone over my time, and so if you have any other questions, I'd be happy to answer them, but
Thank you, Mr. Stewart. Randalls?
May it please the court. Oops. Better. May it please the court. My name is Rebecca Randalls, and I represent the plaintiff, John Doe H.B., in this matter. H.B. was born and raised Catholic. He attended St. Matthew's Parish here in Topeka as a child. When he was a child, Father M.J. worked as a parish priest there. H.B. trusted and relied upon M.J. as his moral compass. M.J. used that vaunted position to sexually abuse the little boy, abusing him during his tenure as an altar boy. Now, in the petition, we set forth that he was abused from the time he began serving, which was approximately 4th grade, until he quit serving. The petition states that he was about the age of 12, and in fact, discovery established that the abuse continued through at least the summer of the time he turned 13, because he turned 13 April 30th, and the new statute came into effect July 1.
Was that 84?
84.
So he turned 13 in 1984.
Yes, he was 1971. He was born April 30th, 1971. He turned 13 April 30th of 1984. The issue is whether or not the abuse continued through the summer, because then the statute of limitations, the new statute of limitations applies. Now, during the course of discovery, our plaintiff did remember 2 further events that occurred even later than that. He remembered one in Christmas of 1984, as well as an abuse event that occurred 2 days prior to the funeral of Mr. Hassett, a friend of his, in May of 1985.
Did you ever try to amend the petition based on those recollections?
You know, we didn't. We weren't to the end of all of the argument concerning the statute of limitations and that kind of thing. And so we were just waiting until we got to a final place, and we would amend the petition, although because the petition does specifically state in the parts where it's talking about timing, it specifically states approximately and about. Neither of those are the kinds of words that generate a judicial admission.
Counsel, I have a question. What's your best argument to explain paragraph 4 of the petition, which says, under parties, at all times material, defendant Father M.J. was a priest at St. Matthew's Parish in Topeka, Kansas, and he is sued herein individually and in his capacity as a priest at St. Matthew's Parish?
And I can tell you that. At all times material, we did state that Father M.J. was a priest at St. Matthew's. And plaintiff testified and alleged that Father M.J. returned to St. Matthew even after he was no longer assigned there, although he didn't know when the assignment ran out. He engaged in sexual abuse of the boy when he returned to St. Matthew's. In that context, Father M.J. was a priest at St. Matthew when he abused the child. Now, in reality, plaintiff didn't know at the time that the petition was filed when Father M.J. was reassigned, and since he came back regularly, he believed M.J. to still be a priest assigned to the parish. That subjective belief does not render the petition an admission against the plaintiff, because plaintiff was abused when M.J. was officially assigned there, as well as when M.J. evidently was not officially assigned there, but still came back and abused him at the parish. So he was at St. Matthew's Parish, at those times when he came back to physically abuse him. The allegations that Father M.J. was a priest at St. Matthew has a further significance beyond the time frame. It establishes his status as a priest, and that it was this status that allowed him access to plaintiff. The status was the hook the priest used to hide the nature of the acts of abuse from the boy. So that particular allegation actually has two significant meanings, and one, a third meaning, that the plaintiff believed at the time that he had been assigned there because he kept coming back. But the mere fact that discovery has later established that he wasn't actually assigned there, he just came back, doesn't render the petition either a judicial admission or render the petition somehow inappropriate because of the pleading of it. I believe, though, that so there are only 3 statements in the entire petition that the defendant is concerned with. And the first is the argument that the abuse occurred from the time plaintiff was approximately 9 years old until he was approximately 12 years old. In that very same allegation, it contains information that plaintiff was between his 4th and 7th grade years when the abuse occurred. Plaintiff has alleged that he believed that 7th grade year extended until he began his 8th grade year, and he did establish during the course of discovery that he was abused during that summer. Now, the fact that Father MJ went to Colorado, I believe it was, for master's work does not establish conclusively that the abuse didn't occur, because even the discovery that Mr. Stewart spoke of showed that he came back. He came back to visit his mother. He was only there for a month. He went out in June of 1983. He came back in July. He was reassigned in 1984. And during all of this time, he was traveling back and forth. This is entirely consistent with plaintiff's petition and with the discovery that was generated. Now, so those are the only 3 facts that defendant is arguing are judicial admissions. Those facts clearly are not made in the nature of judicial admissions. What's more, a judicial admission to rise to the level of estoppel has to have some sort of detrimental reliance by the defendants, and there is no detrimental reliance. Dimension Graphics versus Leibowitz establishes four things that you have to prove before you can have some form of estoppel that would create a judicial admission. The first is a position taken in contradiction to a declaration in a prior judicial action. The second is the actions involve the same parties. The third, the party asserting the theory of estoppel must have changed its position. And fourth, that changed position must have been in reliance on the prior statement. We simply don't have any of those. But I believe the most important issue today is really not so much about any credibility issues that our client has, that you, as the appellate court, don't have the authority to review, but rather the most important is, does Section 523 actually apply to the Archdiocese? I'd like to speak then to that. Section 520.
I'm sorry, just
Yes.
before you move to that, real
Sure.
quickly, again, a real specific fact question. Is it your assertion that your client testified to abuse during either July or August of 1984?
Yes, he testified that the abuse occurred during the summer after his 7th grade
Well,
year.
summer is more, I'm asking July and August. Or did he say summer?
I can't recall specifically, and so I don't want to make a representation that isn't true. My recollection is that his testimony was that it just continued occurring and even into his 8th grade year. But since he had joined sports, it just didn't occur with the same regularity when he went into his 8th grade year.
I'm interested particularly in July and August of
And my
1984.
recollection of his testimony was exactly what I said, that it continued, that it.
Well, and let me follow up on that, on Justice Stiegel's point, I think, is that you've filed kind of generalized factual allegations.
Yes.
And can you do that with the hopes that you're going to just discover something along the way? It seems like that's a little bit of what's happening here based on Justice Stiegel's observation here and just what is occurring here.
Well, to some extent, when you have repressed memory cases, there is a little bit of shooting at a moving target, because many things will trigger new memory. And so we always try to write our petition so that it includes the ability to include the memories that may come up as time goes by, because this abuse occurred over a very long period of time. And so the fact that he wouldn't remember every single event of abuse when it flooded back to him, that's a very common thing. So to some extent, we have to write our petitions kind of broadly and open-ended because as the memories fully congeal, so to speak, there may be slight changes or slight variations in
Well, how
what
does
we
the
pleaded.
Archdiocese and MJ respond to these when it's ever moving? How do they have an opportunity to say, does it ever stop? Does it just keep expanding up to trial date or at least to the pretrial order? What happens in these
Well,
situations?
the issue is always, this is a series of events of sexual abuse. And the case law, and both for criminal and civil, has been very clear that you don't have to specify an exact date of the abuses when it occurs in a series of events. And so that's what we're looking at, is we're
Give-
looking at a whole series of events that occurred over a long period of time.
Given all of that, I guess I'll just ask it straightforwardly. I presume you or whomever drafted the petition knew at the time that your client turned 13 and graduated from 7th.
And a motion to strike and
Well,
some other
but
things.
based
And so
on
we were
everything
just-
you just argued, I mean, couldn't you have said 13 in 8th grade, knowing that you needed to clear that July 1st, 1984 hurdle? It just, I guess was it a mistake in the petition?
It actually was a mistake. Without going too much into attorney-client privilege, my client kept saying, I turned 13 in 85, and we're like, that can't be. It had to have been sometime before that. And so we had an ongoing
So
debate.
is there any obligation on plaintiff and plaintiff's counsel to get that right before you file the petition?
Well, I'd like to say that we've never made a mistake in a petition. Unfortunately, since I'm pretty much by myself, I think the petitions are great until, about 2 weeks after I file them, then I look at them and go, ooh, I missed some things when I was editing. So, yeah, we have an obligation to do our very best to get these things straight. Sometimes I make mistakes, and this was one of those mistakes that I made when I was doing the calculations. But we use, like I say, because there's the possibility of mistake, there's the possibility our client will have additional memory. We always create verbal outs in the petition so that we know that we're talking about approximate dates, but it gives the defendant notice of the time frame that we're talking about.
Well, and just so I think it's important to be really clear here. What I understand you to say is that at the time the petition was filed, your client and as his counsel believed that he turned 13 and graduated from 7th grade in 1985.
Yeah, that's what,
Okay.
yes. Yes, without going too much into attorney-client privilege material there. But the real issue before the court is whether 60-523 applies to individuals only, or does it also apply to the Archdiocese? Beginning in 1990, states across the country began amending their statutes of limitation regarding child abuse of children. Each statute has to be construed on its own language. That said, generally, they fall within two categories: damages or injury-based statutes and primary predator punishment statutes. We call those in the office the PPP statutes. Universally, the states with statutes that have been found to be injury-based apply to causes of action against enabling defendants, like the diocese, while the primary predator statutes have been found to apply only to the individual who commits the physical acts of sexual abuse.
Can you point me to where in the statute 6523 that the legislature, the statute is intended to be read broadly in the way you suggest?
Absolutely. Anytime you have an injury-based statute, those are broadly remedial. Kansas, and the plain language of the Kansas statute places it in the harms-based category. The very first substantive sentence of the statute states, no action for recovery of damages suffered as a result of childhood sexual abuse shall commence more than 3 years after the date the person discovers or reasonably should have discovered the injury or illness caused by childhood sexual abuse. It then defines injury even before defining what sexual abuse is. So the Kansas statute textually is very much in line with those that have determined that this is an injury-based statute. The Texas case, Sabia versus State, explains that the two types of statutes have very different aims. Injury-based statutes are remedial statutes that are designed to assist victims of sexual abuse. Party-based statutes are designed to punish the perpetrators of the abuse. The majority of the states have construed their statutes as allowing cases to proceed against non-perpetrating, enabling defendants. Montana, Oregon, Washington, Connecticut, the District of Columbia, Illinois, Arkansas, Tennessee, Minnesota, and Texas, for example, have all found that their statutes include enabling defendants within their purview. Altamont versus New York Medical College explains that the difference between the majority states and the minority revolves around the text of the statute. Harms-based statutes focus on the particular type of harm, not the parties, like the Kansas statute. For example, the Connecticut statute provided recovery to those suffering personal injury as a result of abuse. The Connecticut court has held that those suffering personal injury as a result of abuse means that this is a harms-based statute and applies to not only the perpetrating defendant, but also the enabling defendant. All of these are broadly remedial statutes, giving survivors who have been voiceless a chance for a day in court. Not allowing an archdiocese who has enabled this kind of abuse for decades to be sued under these statutes eviscerates the common cause, the reason that these statutes have been enacted. Now, defendant argues that Kansas is a primary perpetrator statute, torturing the plain language of the statute. Defendant argues that those primary perpetrator jurisdictions reference criminal statutes in their definition of sexual abuse. It argues then that because Kansas references criminal statutes, it is therefore a primary perpetrator statute. However, that simplistic view glosses over the fact that many of the states that do apply to enabling defendants similarly define sexual abuse using the criminal statutes. Virginia, Illinois, Maine, and others use the criminal sexual assault statutes definitionally, but still apply to non-perpetrating enabling defendants. All of these follow the Kansas formulation, defining sexual abuse by reference to the criminal statutes, but allowing civil actions for acts that don't fall within those criminal statutes. As an example, and Kansas does this as well, some of the statutes have a 14, 12, or 16-year-old element that applies to the criminal statute. But the childhood sexual abuse statute applies to all of those that are under the age of 18. Kansas has followed that formulation. What that shows is that Kansas is using the sexual abuse statutes, the criminal statutes, definitionally to show what childhood sexual abuse means, not to establish that it is the primary perpetrator that it is going after. The primary perpetrator punishment statutes focus on the acts committed by the defendant instead of the harm to the plaintiff. For example, Missouri limits the coverage to claims against a perpetrator only as the Missouri statute defines childhood sexual abuse as any act committed by the defendant that constituted criminal offenses. Therefore, the very language of the Missouri statute defines that the perpetrator, the causes of action must be against the perpetrator of the acts of sexual abuse. The same language underscored the Rhode Island, California, and Colorado cases, as well as the others that the defendant cites in his briefing. However, significantly, the legislatures of those states subsequently amended each of those statutes, Rhode Island, California, and Colorado, indicating that the courts that relied on this got it wrong. Even Kentucky has not definitively ruled on the matter. The case that defendant cites indicates solely in dicta that the statute likely does not cover enabling defendants. That leaves the defense to South Dakota and Utah as the only states that they can point to that have found that the perpetrating defendants are the only ones that can be held liable under the statute of limitations. Because the statute of limitations applies to both defendants, this matter should be remanded to the district court for trial. Does anyone have any questions regarding any of the issues that have arisen today?
We're here on an interlocutory appeal, correct?
Yes.
And so you asked it to be remanded for trial. Isn't there further discovery? If we remand it back, what happens?
Well, we have only done the limited discovery on the issue of statute of limitation. And even that discovery was further truncated because defendant refused to answer most of the interrogatories and requests from the plaintiff. So we still have significant discovery to conduct, but we would ask that it be remanded back to the trial court.
Other questions?
Well, to that end, I just want to make clear in my mind that there was a motion to dismiss filed, and the motion to dismiss was denied. And then there was an order for limited discovery, and then you're up here on an interlocutory appeal regarding the motions for summary judgment.
Yes, that's correct.
Okay.
Which reminds me, I did want to ask you about Mr. Stewart's comment about your not responding to his Rule 141 uncontroverted facts, and that those are all admitted.
Well, if you look at the record, I believe it's 396 to, Volume 1, 396 to 400, you'll see that the uncontroverted facts, we incorporated his uncontroverted facts into the Archdiocesan response as well, so that we had a unified response. So I think we fully responded to them. But even if we didn't, the uncontroverted facts are exactly as he described, that no, I don't remember where I was over the last 30 years. And so they weren't actually something that was harmful to us. If there was an issue, whether or not we responded appropriately. I believe when you look at the record, you'll see that we actually did respond to them appropriately, but perhaps not in the manner that is usual. But I think that we did respond to all of them.
I see here at Volume 1, page 396, plaintiff's opposition to all defendants' motions for summary judgment.
Yes.
Is that what you're referring to?
Yes. Thank you.
You reserve 5 minutes?
I want to turn quickly to the facts before I switch to 60-523. Not only does this petition state all material times he was a priest at St. Matthew's, it further says in paragraph 8 he was his priest, which further underscores all the facts in this case that this occurred while he was a priest at St. Matthew's. But the argument that came up during Ms. Randall's argument, there was no detrimental reliance.
To ask you, if he returns as a priest to St. Matthew's to fulfill some other duties other than the assigned priest, isn't he a priest at St. Matthew's?
He would not be in his capacity as a parish priest, and it would be a different allegation. He's no longer his priest. It's a different priest. It's now a visiting priest. But I want to make clear, this is why I was going with the equitable estoppel argument, judicial estoppel. We had an agreement in the district court that this was a knife's-edge case, and that the case would have a problem and likely be over if MJ had left the parish in June of '83, or whenever he left, before July of '84. We then proceeded with that understanding and that reliance, that if we established when he left the parish, the case would be over if it was before 1984. We did that. It was only then that everything changed. That is the estoppel argument. So not only can you not contradict your facts, you can't change your position that you've lured everybody into by making a representation to the court. That's the Arrowhead case.
Counsel, isn't that an explanation of the facts that would constitute something outside the pleadings?
No, that's a statement by a judicial declaration by counsel which binds the party. So that is just like me getting up an opening argument in front of in a jury trial and saying, these are the facts. You can move for a directed verdict right there based on the admission. It's binding on the client just like a fact pled in a petition is.
But it is outside the pleading.
It is, but it helps show what we were doing and what the district court ordered us to do when we engaged in the limited discovery, and then we relied on that order to then go figure out, okay, where were you? When did you leave the parish? And then developed our summary judgment argument and motion for judgment on the pleadings argument based on that narrowing and limited discovery. That's what the district court wanted us to do, was go figure those dates out.
So just if you could remind me, the district court's order was to engage in limited discovery for the purposes of determining whether or not the statute of limitation had expired. It kind of sounds like you're saying that the order was much more specific to determine exactly when he left the parish.
There's both a handwritten note in the file and the record that says, we've got to figure out, basically says something like, discovery to determine whether priest left in June 1984 or something. I don't remember the exact quote, but it's in the record. And then we had the whole oral argument transcript where the district court provided us his guidance, and Ms. Randalls admitted, yes, I agree, there might be a problem if he left and went to get his master's degree during that summer. And I need to switch to 523, and I'm happy to answer the question.
No, you're fine.
Sure. So when we switch to 60-523, I think the argument is, look, the statute of repose is a substantive argument that provides immunity. The case law is settled. The statutes of repose are favored in the law. They are designed to protect the defendants. They work to benefit my client. They're designed to protect the court from spurious claims. Settled law that exceptions to statute of repose and exceptions to general statutes are narrowly construed, not broadly construed. And the plain language of this statute says, it doesn't say arising from, based on, flowing from. It says no action for recovery of damages suffered as a result of childhood sexual abuse. Stop there. Childhood sexual abuse is specifically defined as a sex crime, and as a result of is the same as saying caused. What this statute says is no action for recovery of damages caused by a sex crime, not caused or contributed to cause by a negligence claim. It does not say any personal injury action like Texas does, arising from a sexual crime. It does not say any cause of action like Montana or Washington that is merely based on a sex crime. And in fact, Colorado has held that when you use based on language, like South Dakota, as long as you define the act as requiring a sex crime, you don't get to include all the other claims of negligence, fraud, whatever. There's something just completely illogical about this interpretation that the legislature would define 15 specific sex crimes, and that's what forms your battery claim against the perpetrator defendant, but yet it can apply to any cause you can think of, fraud, negligence, some intentional tort that merely arises from or flows from those 15 specific statutory criminal acts.
Counsel, but is based on the language used in Colorado, how is that different than as a result of?
Well, as a result of means caused by, according to Black's Law Dictionary. It is a causal element based on, as the statutes like Washington and Montana or Texas say, and many others, they will say based on an action that resulted in. They're using both words. They will use both based on and caused by. So it may be the formulation based on a cause of action that was caused by sexual crime. That's a totally different statute. That is an arising from statute.
So
Counsel?
Under your argument, 6523, your client could never be held responsible.
No, not as long as the 8-year statute of limitations has, 8-year statute of repose has expired, no. And the solution here, if there is one, is not for the court to adopt a new exception or to broadly construe the statute. It's to allow the legislature to address this. And that is what has happened in virtually every state in this country. And there are good reasons to have different statutes of limitations for perpetrators versus non-perpetrators. The non-perpetrator is always going to be removed from that act and have far less information. As this is interpreted, any action flowing from
Well, that's your
abuse-
position, that they have far less information. I mean, as we know, a lot of times,
I think that is necessarily the case. We're not there
Entities like your
unless we're
client.
participating. I mean, it's some kind of act. I mean, a volunteer who has a fleeting relationship with an organization can be sued under this act 40, 50 years after the fact, even though that volunteer only had a minimal relationship with the entity. That's how the Court of Appeals interpreted this statute. And so a lot of states have said, in some situations, a perpetrator will be a family member, someone in the home. I think that's New Jersey. Or it'll be someone who had a clear legal duty to the individual. Some states like Utah actually say all non-perpetrators. But some states, like Oklahoma, says we're going to give more time for claims against the perpetrator, but less time against the claims for the
are
non-perpetrator.
you asking us to actually change the verbiage of the statute?
Not at all, Justice. I think the verbiage of the statute is just like Missouri, just like Kentucky at the time, just like South Dakota. They were all enacted.
Just like Missouri?
Yes.
How is it just like Missouri?
Missouri has the same language. It says no action for recovery of damages caused by a sex crime is how the statute works.
I thought it said something about a perpetrator.
So does this statute. The only difference really between the Kansas.
Where does it say anything about a perpetrator here?
Well, the sexual abuse is defined as an act committed against the person, which act occurred when the person was a minor, and which act would have been a violation. That only applies to a perpetrator. These are acts as defined by sexual crimes.
Why does that only apply to a perpetrator? I don't follow your argument.
Well, each of these criminal statutes that are listed, that are enumerated, they are all only crimes an individual can
Right,
commit.
but we're not talking about those statutes. We're talking about 6523.
Those statutes are all included in 60-523.
Right, but the language says, from when plaintiff discovered that injuries resulted from childhood sexual abuse.
But it says, I'm way over time, I'm happy to keep answering the questions. It says a couple things. One, the damages has to be caused by childhood sexual abuse, which is specifically defined.
It doesn't
term.
say caused by a perpetrator. It says caused by.
Childhood sexual abuse, which can only be committed based on how it's defined by an individual. This is exactly what Missouri has held. It has virtually similar crimes: incest, exploitation, sexual battery with a minor. All these statutes were enacted all around the same time. Now, they've changed since then. But if you look at South Dakota, Missouri, Kentucky, Rhode Island, Kansas, they use almost identical language. And those other 4 states have all held these are perpetrator-only statutes because the act is defined as a sex crime that only an individual can commit.
And how could the church ever be sued, even within the statute of limitations?
You have to be sued timely, either within.
But how? If they weren't the perpetrator?
Well, the general statute of limitations would still apply then. The 2-year statutes for negligence, or if this is an action against minors, the minor would have normal, just like we would for any other tort claim, until after reaching the age of majority to bring the suit. But this is a special.
Okay, so then it's your position that the church, where under that 523 doesn't apply to the church, and the church could be sued under negligence or one of the 2-year.
Correct. That's exactly what.
And that's what all the other states that you're talking about hold.
Is exactly what they've held. Kansas is somewhat unique because we have adopted an even stronger policy than those states by having a statute of repose. So our legislature has said, at some point, your claim is abolished. 8 years is too long. And we've adopted an exception to that generally applicable rule
What do you think the legislature's intent in doing that was?
to prevent stale claims, spurious claims, claims where evidence is lost, memories are
Well, no,
lost.
because the legislature specifically said from when the plaintiff discovers. This isn't when the act occurred, right?
Correct, that's the accrual part of this. And that's also an interesting wrinkle because the claim runs from when you discovered so a normal statute of limitations, your claim would run once it's accrued and you notice you have a claim against any number of defendants. But in this situation, it's narrow. This statute of limitations only begins to run when you realize that someone abused you and you've been damaged because of that. So it's against a narrow claim, it accrues generally for everybody and every defendant in the world like a normal statute of limitations would. So I think reading that language, it actually supports my position and shows why it's a narrow perpetrator cause statute.
Okay.
I have a quick follow-up. I understand your argument, I think, that because this statute of repose is framed in the language of criminal liability, you have to have committed a crime.
Well, the statute of limitations, special sex abuse, special statute of limitations for sex crimes, which is an exception
Right.
to the statute of repose.
And that's why
is-
you're
is-
claiming that your client cannot be, that the time period cannot be extended against your client.
Correct. We would
Because
have-
your client can't commit a sex crime, basically.
You're right, we can.
You
commit those.
said repeatedly, this is the kind of thing that only an individual can do. And I want to examine that proposition a little bit, because in the petition, the plaintiff does allege under each count that the Archdiocese aided and abetted.
Right.
And that's language of criminal liability. And so isn't that enough to allege that, in fact, the Archdiocese did effectively commit a sex crime?
There are certainly criminal statutes on the books that will allow criminal acts to be filed against corporations or organizations. There are certainly aiding and abetting crimes. None of those are listed in the 15 specifically.
Do you have case law that says that there is no aiding and abetting liability for a sex crime in Kansas?
No, I'm not saying that.
Well, that's the allegation. I understand that it might be fanciful, no evidence, whatever, but it's in the petition.
My argument is, if that's what the legislature wanted to include, it could have certainly added any number of additional criminal statutes into this very specific
Well,
list of crimes.
I think we're talking past one another. I accept for the purpose of the question, your premise that the plaintiff has to establish that a sex crime was committed to enable them to expand the time limitation to get at your client. But I'm just saying, isn't that what the petition says? The petition says the Archdiocese committed a sex crime against my client. That's what the petition says as I read it.
Number one, I think that's legally impossible because as a matter of law.
That's what I was asking. Do you have
any-
case law that says
Well,
that?
I think the easiest answer is any act done to abuse a child is always, as a matter of law, outside the course and scope of employment, right? I mean, just, whatever he was doing was for himself, not for us as the employer. That's, I mean, universal. Every state has that law. So we'd have to find something that said that we actually did aid and abet. Well, even if we aided and abetted, that would still have to be a criminal act that would be included in this statute. That criminal act is not included. This,
Aiding and abetting liability is not a separate crime. It's just a different theory of liability under the principal crime.
well, that would turn you to subsection B2, which again defines abuse as an act committed against the person. And that act would have been a violation. We cannot commit the
Okay,
acts.
you're
defined in the
just
statute.
relying on the fact, or on the argument that a corporate entity cannot aid and abet.
I'm not saying.
It'd
that a
have to be
corporate-
an individual.
I'm not saying a corporate can't aid and abet. What I'm saying, if that was the case and the statute was going to be broader to include those types of criminal acts, the legislature could have included that, but it did not. And we have to narrowly construe this statute and cannot add in new words or new statutes or new criminal theories that the legislature did not adopt in a statute that has to be, as a matter of law, narrowly construed to protect the statute of repose. Thank you for the additional time, Your Honors. I appreciate the time today.
Thank you to both counsel for your arguments. The court will take this appeal under advisement.